Hi, my name is Stephanie Cagnett-Myron, and I'm on the Florida Bar Board of Governors for the Young Lawyers Division out of the 15th Circuit here in Palm Beach County. I also have my own victims' rights law firm, Cagnett-Myron Law. Today I'm here to talk to you about injunctions. They're also known as no-contact orders, restraining orders. This is a great way for young lawyers to get involved and take pro bono cases. Through the Florida Bar Foundation, there's a list of all of the local legal aid organizations and the point of contact, so you can reach out to legal aid and take these cases pro bono. This is also a great way to expand your practice area to take injunction cases. They're typically very fast-paced, so once you get a case, it's set for hearing within about 2 weeks. When you have these cases, there are technically 3 different areas where you have stalking, domestic violence. You have the injunction, which is technically in family court, but there doesn't have to be a familial relationship. You also have a criminal case, which could be going on at the same time for domestic violence, for stalking. And you could also have a separate civil action going on for defamation, tortious interference, what have you. But today we're just going to focus on the injunction, which is in family court. In the injunction, it is the victim, which is the petitioner, versus the respondent, the defendant. This is supposed to be a temporary solution. They're typically put in place for 3 months, 6 months, a year, and in some cases, it's until further order of the court. And that means that it's in place until one of the parties moves to have it vacated. And this could be a couple years down the line. Once the respondent says, I went to therapy, I went to some type of a program, and what was causing that issue is no longer an issue, and I think it should be vacated. So the steps to take in the injunction process. You have safety planning, which is a very important factor for domestic violence cases, sexual violence cases, dating violence, stalking. You want to make sure that when you have the victim who comes for help, the first thing that you do is think about safety planning. Put them in contact with victim advocates, victim services. There's typically someone in victim services at every courthouse to provide therapy, which is free for the victims. You also have police officers. You need to put them in contact with the local police officers to make sure that they're alert with what's going on, so that if they have to call 911, they already have a written record and they know what they're responding to. And so then, after the safety planning, you help with drafting the injunction, the petition for injunction. Once you file the petition for injunction, there are other documents which need to be submitted as well. So there's a cover sheet, notice of related cases, and notice of limited appearance, which is important because you are appearing for the sole purpose of the injunction hearing. If they have other related family law cases that are pending, you don't want to be an attorney of record for all of those issues. And after the fact, after the injunction hearing takes place or the case is dismissed, you want to file the notice of termination of appearance, which means you are no longer representing them, so that the actual victim is served notice. If later down the line the respondent files anything in the court record, then the victim has to be served personally, and they won't just try to send it to your law office and find that that is sufficient. So you want it to go directly to the victim after the fact, and so that's why you have to do the notice of termination of appearance. You want to ensure that the respondent is served after you file the petition, and typically the sheriff's office in the local jurisdiction will handle the service of process. And they have the return of service that needs to be submitted to the court, so you need to check the court record to make sure that the respondent has been served. If the respondent has not been served by the time the actual hearing takes place, you can request for a continuance. And if you think that they're dodging service, you may actually want to hire a private process server to ensure that the respondent is served. If they are out of county, it's usually a good idea to hire a private process server to make sure that they are served timely. And that you can do by just researching the private process servers, but you want to request that of the judge before just hiring a private process server, so that in the order they actually write, that they can use a private process server to serve process, so it would be valid. You actually attend the hearing, and so for the hearing, you want to make sure that you have subpoenaed any phone records you may need. You have screenshots of all the emails, text messages, phone calls, any photographs of injuries. You want to make sure you have 3 copies of everything, one for you, one for opposing counsel or the pro se respondent, and also a copy for the judge so everyone can clearly follow along while the witness is testifying. You also want to make sure that you enter those documents into evidence at the hearing to preserve your record. You want to subpoena any police officers who may have been involved, who have been called to incidents. You want to subpoena any witnesses. And sometimes the law enforcement officer, if you reach out to them via email, they will just accept service via email. You don't actually have to go through the expense of paying to have them served. And the same for any witnesses that you have. You may not have to actually pay to have the subpoena served on them. They may just accept it via email. If you go through the injunction hearing and it's denied, you can continue to have your client document any incidents after the fact. They are not precluded from refiling. So if they have, you go through the injunction hearing and then the respondent continues to call or continues to harass them, then you refile the injunction and you note everything that's happened in the past and then everything that happened after that injunction hearing, and they continued that activity. If the injunction is granted, you want to make sure that the victim makes multiple copies of that order. They will get the order that day before they leave. And you want to go through, and I have copies of the injunction of the order, and we'll go through that in detail later on. But you want to make sure that they keep a copy in their purse, in their car, at their work, at their house. Because if they ever have to call for a violation of injunction, you want to make sure that they have a copy on hand that they can give the law enforcement officer and that they don't lose their only copy. And then after the injunction hearing, you want to file the notice of termination of limited appearance. You want to make sure that if your victim, if their information is confidential, if they don't want their address disclosed, that you don't actually file their address on the petition for injunction or on any of the termination of appearance where you have to indicate where the paperwork should be served. And you want to make sure that you tell the victim to report any violations of injunction immediately to law enforcement. Call 911, report the violation immediately. Take a screenshot of what's happening. Make sure you save a log of the date, time, who was present, what witnesses were there. You want to make sure the location, any information. Just make sure that you try to remind them to document it as soon as it happens, because after the fact you may forget something. And you also want to make sure that the victim has a written statement that they provide to law enforcement once they respond to report any violations. The family law forms. So all of these forms that I've just talked about, they're all listed on flcourts.org, and that's flcourts.org. And I've taken a screenshot of that image so that you know exactly what you're looking at and to make sure you're on the right page. There are multiple types of injunctions. There's about 5 separate issues that you can file a restraining order or an injunction for. There's domestic violence, repeat violence, sexual violence, dating violence, and stalking. And you can see in red on the screenshot of the homepage for Florida Courts, flcourts.org, it says domestic, repeat, sexual, or dating violence, stalking. And you click on that, and that'll take you to the page which you see in the next slide, where it has all of the forms that you need. So it's designed, it's very easy to use, this system that they have. It has all of the forms that you need, because you see a lot of times people do file these pro se. And so it's very user-friendly on this website. And you see domestic violence 12.980 forms A through E. So you click on the petition for injunction for protection against domestic violence, and they have the same forms for repeat violence, supporting documents that you need, dating violence, stalking. All of those documents are found here on that website. On the next page, it's another screenshot further down the page of all the other forms for sexual violence, stalking, and show cause for violations. So types of domestic violence, we're going to break each area down by the subject matter. So if you're filing a petition for injunction for domestic violence, it includes assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any other criminal offense resulting in physical injury or death to the petitioner by any of the petitioner's family or household members. And that is a very key issue. So factors to determine reasonable cause to believe that the victim is in imminent fear of danger or of becoming a victim of domestic violence. And so I have a long list of different factors, but these are all things to consider, especially when you're drafting the petition. You can include all of this information in the petition. And when you do draft the petition, you want to make sure that it is as detailed as possible, date, time. You also want to write who was there, who's present, who would actually be able to testify to this information. If the victim had to call to make a police report, reference that police report number, who the officer was that responded, and what was the result of that, the response from the police officer. Did the officer contact the respondent and say, stop contacting this victim? And then after the fact, did the respondent continue to contact the victim? These are all things that are very important to keep in the initial petition and the narrative, and also during the hearing to make sure that this comes across clearly to make a clear record. So the court must consider all relevant factors alleged in the petition, including but not limited to. So this is not an exclusive list. And what I'm referring to is what is actually found whenever you click on the petition for domestic violence. So they're designed for pro se individuals to be able to go through and file this themselves. And so they have a very specific list. So the first 2 pages, they're just instructions to help with the filing and to help explain the process to the victim. And so the court can consider the history between the petitioner and respondent, any threats, harassment, stalking, or physical abuse that has occurred, whether the respondent has attempted to harm the petitioner or family members or individuals closely associated with the petitioner, whether the respondent has threatened to conceal, kidnap, or harm the petitioner's child or children, whether the respondent has intentionally injured or killed a family pet, whether the respondent has used, threatened to use against the petitioner any weapons such as guns or knives, whether the respondent has physically restrained the petitioner from leaving the home or calling law enforcement, whether the respondent has a criminal history involving violence or threat of violence, the existence of a verifiable order of protection issued previously or from another jurisdiction, whether the respondent has destroyed personal property, including but not limited to telephones, other communication equipment, clothing, other items belonging to the petitioner, whether the respondent engaged in any other behavior or conduct that leads the petitioner to have reasonable cause to believe that he or she is in imminent danger of becoming a victim of domestic violence. Now, for the domestic violence injunction, it requires a domestic relationship. And so it only applies if it's against your spouse, former spouse, someone who's related by blood or marriage, someone who's living with you now or has lived with you in the past, if they were living together as a family, so not just a roommate, or other parent of your children, whether or not you have ever been married or living together. So if it's the co-parent, you can file it under the domestic violence injunction as well. Repeat violence. So this is a separate basis for injunction. For repeat violence, it means that 2 incidents of violence, and that is what is described in the domestic violence section, that 2 incidents have been committed against you or a member of your immediate family by another person. So one of those 2 occurrences must have been within the last 6 months of filing this petition. And it's very important whenever a judge reviews it, either during the initial review of the petition or during the actual trial, they look for what's happening recently. So if this behavior was long in the past, this is for any injunction, it won't weigh as heavily. So you want to really focus on what's going on now, what's recent. And that's why it's very important to get the injunctions filed as quickly as possible, because if there's a gap in time, a judge may be less willing, or they may not think it's as necessary to protect the victim at that point in time. And so with repeat violence, one of the 2 incidences must have been within 6 months of filing the petition. Another basis, sexual violence. So sexual violence means any one incident of sexual battery as defined in Chapter 794 Florida statute. It's a lewd or lascivious act and that's defined in Chapter 800 Florida statutes, and it's committed upon or in the presence of a person younger than 16 years of age. Luring or enticing a child is described in 787 Florida statute, or a sexual performance by a child is described in Chapter 827 Florida statute, or any other forcible felony wherein a sexual act is committed or attempted. For sexual violence, the victim must have reported the sexual violence to a law enforcement agency and be cooperating in the criminal proceeding if there is one. It doesn't matter if the criminal charges based on that sexual violence have been filed, reduced, or dismissed by the state attorney's office. You can also seek an injunction for protection against sexual violence if the respondent was sent to prison for committing one of the sexual violence crimes listed previously against you or the victim or the minor child living at home, and the respondent is out of prison or is getting out of prison within 90 days of your petition. You also want to attach the notice of inmate release to your petition if they have actually been released. Another basis for injunction, a separate petition, is for dating violence or a reasonable fear of dating violence. And that's the violence between individuals who have or had a continuing and significant relationship of a romantic or intimate nature. The dating relationship must have existed within the past 6 months. The nature of the relationship must have been characterized by the expectation of affection or sexual involvement between the parties. The frequency and type of interaction must have included that the persons have been involved over time or on a continuous basis during the course of that relationship. It does not include violence in a casual acquaintance or violence between individuals who have only engaged in ordinary fraternization or business or social context. Stalking is another basis for injunction. It is the repeated pattern of unwanted contact that with no legitimate purpose, and it causes substantial emotional distress. This contact could include someone showing up at your house, at your work, at your school. They can use technology. There is actually a basis for cyber stalking under the stalking statute. So if it's the use of electronic communication, calls, text messages, emails, or any form of electronic messaging on social media. As a victim of stalking, you can proceed with a civil injunction. This is referred to as a restraining order or no contact order, and this is when it's the victim versus the defendant. Stalking is also a separate crime in Florida. It's a misdemeanor punishable by up to 1 year in jail. If there is a credible threat, then it rises to a felony. The criminal case is the state of Florida versus the defendant. Drafting the petition for injunction. So your goal whenever you are drafting the petition and you're going through everything with your client, you want to create a clear timeline so that the judge has an understanding of what's going on. They know how the victim and respondent know each other. So what caused this? They also want to know the timing of events. So what happened after they either broke up or, depending on the nature, what was it? What was that trigger and why is this happening? And so you want to make sure that you have a detailed timeline in the narrative of the petition, and we're going to go through that shortly. The narrative should be written in the first person. So it's written as if the victim is speaking, because at the end, the victim actually has to sign the sworn statement notarizing that document. It needs to be as detailed as possible. Date, time, who was present, were the police called, were there any actual threats that were said, implied, were they aggressive, the volume, so how many times did that person call, when was it, do you have screenshots of that, can you get the screenshots from the phone company, any of the text messages, will the phone company provide copies of those text messages if they may have been deleted? What steps were taken to resolve this before filing the injunction? For stalking, you want to focus on the contact which occurred after the victim made it clear to the respondent to stop contacting them. If there's back and forth communication, this will not be considered stalking. So it needs to be a clean line in the sand of when the victim says, stop contacting me, and then they don't respond. Or if they do respond, the only response is, stop contacting me. You attach screenshots of the related text messages, emails, call logs, photographs of injuries, any evidence that you think is important for the judge to review when deciding whether to grant that temporary injunction when they set the hearing. And you want to also put the respondent on notice. You don't want to give them any basis to request a continuance because they may not have seen the documents or had time to adequately prepare. So if you attach it to the petition and they're served a copy of the petition and those attachments, then they have no basis to argue that they weren't aware or they weren't on notice. Prior to filing the petition, you want to make sure that you have the victim sit down and review the petition in detail. Make sure everything is accurate because it is a sworn statement. The petition needs to be notarized before filing. The clerk is able to or someone at the clerk's office is able to notarize the document at the courthouse. The victim will need to have their driver's license or ID to have that document notarized. So on this slide, what we see is I actually went to the Florida Court's website and I took screenshots of the petition for injunction as it's seen, as it appears through the website. And so what you do is you enter in the name of the petitioner or respondent. There is no case number or division yet. That will be assigned later. But you want to make sure that you also include the circuit and the county. You want to fill in all that information. Fill in all of the blanks. Make sure it's very detailed. Now, when you're describing the petitioner, if you don't want, now everything in this petition will be served to the respondent. So if you don't want to disclose their address, so say the respondent, maybe they had to move to hide, you do not want to put that information in this petition because the respondent will have it and it will be in court record. And you do not want it to be your fault that the respondent finds that victim. And so you want to make sure that you just write confidential if the information is in fact confidential. You want to provide as much information about the respondent, the address, if you know where the address is, or if you know where they work, where they can be served. The more detail you can provide, the better. For this petition on this next page, it's for the domestic violence petition for injunction. And so there's a lot of other information that's required in this petition. So you want to go through every element in detail that's required. How long they've known each other, the last known place of employment for the respondent, when they work there, what the address is, make sure that all of this is accurate because you want to try to provide as much information to get the respondent served. And so it's also the physical description, make sure all of that is provided in detail. Any nicknames, aliases, if they have an attorney that you're aware of, provide that information. The case history, go through, have they ever tried to get an injunction in the past? Yes, no, what happened? Has the respondent ever tried to get an injunction in the past against you? And a lot of times you can see that the respondents, they file either false police reports or they file injunctions in the past which may be denied without setting a hearing. And that can be used as an additional way to stalk the victim. So you really want to go through that in detail and what happened. And if although you can't use something that the respondent is legally entitled to do as a basis for the injunction, I've been able to argue in the past that it was a false police report. It was a false action that was filed. It was a false reporting to DCF. And so that is not something they're legally entitled to do. They're not entitled to make a false report. And so that's kind of the way I've been able to argue it successfully. You also want to describe in detail, check every box on subsection 4 of, anything that they've done, under those elements, the things the court can consider in the past. And even if it's not the recent past, you still want to make the court aware of it. So make sure you check every box that applies. And now on this next page, you see on date at location, and then there's a blank. What I typically do is I do since and then the date that it started. And then I say, please see attached. And I go through and I attach an actual Word document, which has a detailed timeline. And so then you have adequate space to make sure you get everything in there. And so that you aren't limited to just the space that's provided. And then you check the box saying, please indicate here if you're attaching additional pages to continue these facts. And then there's also additional information about, do they have a drug or alcohol problem? Do they own weapons? And the domestic violence petition, it goes through a lot of information about temporary use or exclusive use and possession of the home. You have a parenting plan, time-sharing schedule of minor children. There's a lot of other things to consider. There's also a temporary support. So all of these things can be requested through the injunction process. However, this is where it's important to know your judge, because some judges who see this, and especially the request of support, and even though the victim is within their rights to do so, sometimes it's used against them, and it's a red flag in the eyes of the judge, and they view it as an improper use of the injunction tool, that they're not really concerned with their safety or their children's safety, but it's a backdoor way to try to quickly resolve any dispute about use of the home or time sharing of the children. And so you want to be very, very careful whenever you are requesting this to make sure that it doesn't appear that you're just using this as an improper tool, and that the safety is the main concern in filing the injunction. And also you see where it has to be signed and dated by the petitioner. There is the space on the actual document to have it notarized. And once the petition is filed, and you can e-file it, and so the judge, there's always a judge on duty Monday through Friday during work hours to review the petition, and it should be reviewed that day. If not, it should be reviewed the day after. And when the judge reviews the petition, they will either grant a temporary injunction upon reviewing and set it for a hearing within a 2-week period, or they can set it for a hearing without issuing a temporary injunction, but the victim has the opportunity at the hearing to come forward and explain the issues and to see if there is a basis to grant an injunction at that time. Or third, the judge could deny it outright and not set it for a hearing. If that happens, you really want to look through the petition in detail and the narrative and make sure that everything's coming across clearly, that you meet all of those required elements, and then you may want to refile if you feel that there is a sufficient basis and it was improperly denied. Just make sure you go through and provide additional detail, additional documentation. Try to make it as clear as possible as to why you think that injunction is necessary. If an injunction was already filed, so if you are taking a case pro bono, or if someone is contacting you and they already have a hearing date. So at most courthouses, victim services, they have victim advocates on duty to assist with the drafting of the petition. And so they may have already filed the petition and have a hearing date set by the time that you're even contacted. And so if this happens, you want to review that petition in detail and make sure that every instance is included. Screenshots are included. Maybe there's things that have happened now since the filing of the petition, and you may want to do a supplemental petition. So you just do an additional narrative portion for the petition, and you file it with the court, and you have it served on the respondent. And that way the respondent is on notice of everything that you are going to allege during the hearing. Due process requires you need to make sure that anything you're going to talk about in the hearing that the respondent is aware of in the petition or in the supplemental petition. And what I've done is I've taken a screenshot from the Florida Court's website of the page that shows any additional supporting documents that you need. So if you are requesting, temporary alimony, child support, there is a family law financial affidavit that needs to be filled out, the Uniform Child Custody Jurisdiction and Enforcement Affidavit. So if these are things that are going to come up in the domestic violence injunction, you want to make sure that you attach the needed supplemental documentation. You also see at the top here the notice of limited appearance. So you already have a form document you can use. It's already readily available. Just put in your information and file it. The termination of limited appearance, that form is right here on the page as well. It's 12.900, and that is subsection D is the termination of limited appearance. So make sure you either have it ready, so at the hearing, as soon as it's resolved, you file it with the court there in person, or you go home and you e-file it. So the injunction hearing itself, you want to make sure that all subpoenas have been timely issued for witnesses, officers, phone records. You may have had to issue a subpoena for a phone record. Now these typically take months to get in. So if that's the case, you want to make sure that you timely file a motion for continuance and you state the basis of why you need that continuance, why those phone records are so important. The petitioner has the burden to prove the case at the hearing. So the respondent, they have to be served, but they don't even have to appear. but you need to make sure that even if the respondent isn't present, that you put a factual basis on the record as to why it should be granted. You want to bring any related case law if there's any special issues in your case. You never know what the other side might argue if they're represented, what the judge might ask you, and you want to make sure that you have those cases, and always make sure you have 3 copies of any case you think might be important, that you have it with you and readily available. It's a full evidentiary hearing. You call witnesses, you put forth the evidence through testimony and physical evidence, you enter that evidence. You want to make sure that you know the proper predicate to get everything in. And you also want to make sure that you create a clear record. The hearings in domestic violence court, which is the umbrella of what all of these cases are called. So any injunction is technically in domestic violence court, even if it's not a domestic violence case. They're all recorded by the court. So you want to make sure that you inform the victim to speak clearly into the microphone. They can't record nonverbal, so no shaking. It's basically like a deposition. You want to make sure that everything is clear for the record and also not speaking over one another. And you want to make sure that you don't have to call in a court reporter or have your client go through that expense because it's already recorded, and you can request copies of that, either the audio recording or you can have it transcribed. And you just contact the clerk's office, and there should be instructions on your local clerk website of how to do that. Now I've attached a copy of the final judgment of injunction for protection against stalking. And so this is specifically for the stalking case, but they have copies of the final judgment. Now you don't have to go to the hearing with a prepared final judgment. It's not like typical civil court where you have to submit a proposed order. Now these are form documents that are used. The court will already have one available. And I just wanted to go through this so that you know what to look for. And say you are able to reach an agreed order. These are things you need to make sure are included, so there's no basis to challenge that order later on. And so you have the final judgment of injunction for protection against stalking, and this says after notice, so it shows that they were served or they appeared and waived the proper service. They either check the box saying that it should be issued, modified, or extended. So that means that's either, maybe it was just an order setting hearing and there was no temporary in place. So then they check the box that says issued. Maybe there's different terms now. So there was a temporary that was entered upon initial review, and now at the hearing, maybe there are additional addresses that need to be included. Maybe it needs to specifically list the client's work address or the school where their children go. And so then you would check the box that says modified. Or if it's the same exact terms that were entered in the temporary upon initial review, it would just be extended. So those same terms would still apply throughout. And so the box would be checked that says extended. And then you also check the box of everyone who was present for the hearing. And so you make sure that everyone is properly checked. And then on the date that the actual respondent was served, so this is also in the record, that they were served and they were served on this date. And then you look at the next page, section 3, the terms. So the injunction shall be in full force and effect until either, the first box, further order of the court. And now this means it's a permanent injunction. And so it's in place forever until one of the parties files a motion to have it vacated. And this could happen 2 years down the line, 10 years down the line. And that's why it's very important to have that notice of termination filed with the court, so that, say, the respondent 10 years from now files a motion to have it vacated. You don't get this random notice of a hearing being set. Forget what it's about. You haven't talked to your client in 10 years. Now you don't know where they are, but they've served you. You want to make sure that it's actually the victim that's going to be served, so that they know and they can appear and contest that hearing. Or now the second box is until date. And so this is where if the judge grants it for 3 months, 6 months, 1 year, it's from the date of the hearing. And so you want to make sure that if the judge says, I'm going to grant it for 6 months and then puts the wrong date in there, this is something you want to look at, because you want to make sure that your client is protected for the period of time that the judge actually granted. Now it goes through the prohibited acts. And so for the it goes through and it says, willful violation of this injunction. So if they commit an act of stalking against the petitioner, if they go within 500 feet of the petitioner's home. Now this is whether they're home or not. And so that's where it's good to let the neighbors know, to have security cameras. Because if you can prove, and if they see the respondent drive past within 500 feet, have them snap a picture, to prove it, that they violated that injunction. So even if the victim's not home, the respondent is still prohibited from going there. And now this also applies to their place of employment. So if the respondent goes to their work, even if they're not there, it's a violation. If they go to their school, even if the victim's not there, it's still a violation. Or any other place that's specifically prohibited in this injunction. So say every week there's a family dinner on Sundays at the parents' house. You can include that. If it's a place that you frequently visit and you want to make sure the respondent doesn't go there, you can indicate it on the petition and request it as part of the order. You also have the respondent prohibited from knowingly and intentionally coming within 100 feet of the petitioner's vehicle. So if they see it parked in a parking lot, they can't go up to it, leave notes, anything like that. Even if the victim's not in the vehicle, they still cannot go within 100 feet of that vehicle. Any violation of the injunction through an intentional unlawful threat, a word or act to do violence to the petitioner, calling the petitioner, contacting or communicating with them unless it's indirect contact through a third party is specifically allowed in this injunction. And so what that means is, say they are co-parents and they have to work out some kind of a parenting plan, but the respondent can't contact the victim. Now you want to make sure that you specifically list who they can contact. So if they are going to do one of their parents, and so all communication is going to go through one of their parents. Or say that they use a Talking Parents app or one of the applications that's available that's monitored, and it's a written communication that's monitored. They may be able to use something like that to arrange the co-parenting schedule. Now, it's very important. Sometimes the parent tries to get an injunction on behalf of a minor child, but the parent doesn't have direct knowledge of those incidents. So say the child tells them something, that's hearsay, and the court, you have to file a motion if you want a minor to testify, but the court is very reluctant to grant these motions and put these children in that type of a position. Now, DCF, there is a separate injunction process, and it's a little more kid-friendly, and it's a little more lenient. And so if there is a need for an injunction on behalf of a minor child, but the parent who's filing it, they don't have that personal knowledge, make sure that they go through DCF, and that would be the proper route to have the injunction put in place, and that's through a completely separate system, and DCF would handle that process. Another violation of this injunction, if there's indirect contact through a third party, so it's not specifically authorized in this order. So say the respondent contacts the victim's parents, their friend, their roommate, to get a message to the victim. That is a violation through indirect contact, and that also needs to be reported immediately to police. Any defacing or destroying of the petitioner's personal property, so their vehicle, or if they have care, custody, use, or possession of a firearm or ammunition unless authorized under section 790.233 subsection C3 Florida statute. That would be a misdemeanor of the first degree punishable pursuant to section 775.082 and 775.083 Florida statute. And so what you'll see in a few minutes is that the order of injunction actually prohibits the use of firearms unless they are law enforcement and they're required to have it in their normal use and duty as a law enforcement officer. That is one of the very few exceptions, but pursuant to this specific language of this rule, you have to make sure that those boxes are checked. So even if the victim doesn't know that the respondent has a gun, they may not be aware, you still want to make sure those boxes are checked. Now, if the victim knows that the respondent has a gun or weapons, I think it's very important that they let law enforcement know, or have it even written in the order near this portion. Have the judge write, well, they have, this type of a gun. It's kept here. I know that they do. They have a license. They don't have a license for this gun. Any weapons that they're aware of, you want to make sure are specifically listed, and that the victim goes a step beyond, and you provide that information to law enforcement, because they are supposed to go and actually take those weapons and hold those weapons throughout the duration of this injunction. Any party violating this injunction shall be subject to civil or indirect criminal contempt proceedings, including imprisonment or fine, and also may be charged with a crime punishable by a fine, jail, or both, as provided by Florida statute. And the prohibited actions, everything listed in here for this stalking injunction, it prohibits stalking, cyber stalking, any threats. The order under subsection 2 specifically says no contact. Respondent shall have no contact with petitioner unless otherwise provided in this section. So if it doesn't specifically list an exception, then there is no contact allowed whatsoever. And that's where it lists the petitioner's current residence. And so if it's confidential, it should still be listed as confidential here, because the respondent gets a copy of this. Any current or subsequent employment. So they don't even have, so say the victim changes jobs, they don't have to file a notice with the court. They just have to be able to establish to police when they report the violation that, yes, I am in fact working here, yes, the respondent came here. And you want to list the school unless it's supposed to be confidential. So if the respondent doesn't already have that information, you do not want to provide them with that information. Any places frequently visited by the petitioner, and any named family members or individuals closely associated with the petitioner. And now here is where you list that specific information. And it makes it easier. So if it's something that respondent already knows, then it doesn't really do any harm to list this information, and actually makes it easier if it is listed. So say you have a violation you need to report to law enforcement. It's much easier to prove that violation if that address or that person is specifically listed in here. They can't argue they weren't on notice. And this also goes into detail again about the 100 feet of the victim's vehicle, whether or not it's occupied. They can't deface or destroy personal property, or any other specific provisions regarding contact. And so that's where it's important beforehand to kind of go through this with your client and see, where do you frequently visit? Is there anything that is interesting about your case, or facts that the judge may not think of? Any other places that you would like to be protected that you frequently visit? And subsection 3 is very important. So it's the firearms section. And so it says, unless paragraph A as initialed below, respondent shall not have in his or her care, custody, possession, or control any firearm or ammunition. It is a violation of section 790.233 Florida statute, a first-degree misdemeanor for respondent to have in his or her care, custody, possession, or control any firearm or ammunition. Now, we've recently seen some judges who try to say, well, they have discretion over this provision. There is nothing I've seen. There's no law, there's no requirement or anything giving judges discretion. This is a mandatory provision. So make sure that you voice that on the record. If the judge tries to say, I don't feel that the firearms section applies, I don't want to take away their guns, then you want to make sure that you object on the record, and this could be a basis for appeal. So subsection A specifically states for the firearms provision that if it's a state or local officer as defined under section 943.10 subsection 14 Florida statutes who holds an active certification, who receives or possesses a firearm or ammunition for use in performing the official duties on behalf of the officer's employing agency, and it's not prohibited by the court from having in their custody or care or possession any firearm or ammunition. So if they are a state or local officer under that provision, that is the only exception to this provision. And when you are going through the order after you receive it, you want to make sure that if there's any blank provision, that it says NA or none or does not apply. You do not want to have a blank portion on this on the actual order. So even after you receive it, before you leave there, make sure you review it with your client and you say if there's any blank provision, you ask the judge to make sure that it's all, if it doesn't apply, just write NA, but make sure there is something there so it's not a blank left on the order. So treatment, intervention, counseling. I've never actually seen this entered as a portion of the injunction. However, they do have the ability to do so, so you can still ask. So say that alcohol is related in all of the underlying instances. You can request that the court require the respondent to participate in treatment or intervention or counseling for that specific issue. And in subsection 4 is where you would write that information. However, as a practical matter, it's rarely granted, but it's still, if you think that that is the root of the issues, it's still something that you should request. The mailing address or designated email address. So the respondent has the requirement to notify the clerk of any change in the mailing address, their email address, within 10 days of that change. So the respondent has that requirement, and they have to provide that information within 10 days. All further papers shall be served either by mail to the respondent's last known mailing address or by email to their designated email address. And any additional provisions, so if there's any other issues that are very unique in your case, you include that information here. And if there are no other services or provisions needed, so say subsection 6 or 7 don't apply, make sure you write NA on those portions. At the top of the last page where the judge signs, you want to make sure there is a very small line at the top saying other special provisions. And you want to make sure that you write NA if there's nothing you want to write there, just so that there is no room for argument. The directions to law enforcement in enforcing this injunction. Now, in this order, there are very specific provisions. This injunction is valid and enforceable in all counties in the state of Florida. So even if the injunction is entered in Palm Beach County, but the violation is in Broward, it's still enforceable regardless. The violation should be reported to the appropriate law enforcement agency. So just call 911 and go to a public place, make sure you're in a safe place, have the victim report it immediately. The law enforcement officers of the jurisdiction in which a violation of this injunction occurs shall enforce the provisions of this injunction and are authorized to arrest without a warrant pursuant to Section 901.15 Florida statute for any violation of these provisions, and it constitutes a criminal act under Section 784.0485 Florida statute. And it goes on to say this injunction is enforceable in all counties in Florida, and law enforcement officers may effect arrest pursuant to Section 901.15 subsection 6 Florida statutes. The arresting agents shall notify the state attorney's office immediately after arrest. And then that's when the case is reviewed for the criminal charge of violation of injunction. Reporting the alleged violations. If respondent violates the terms of the injunction and has not been arrested, petitioner may contact the clerk of court in the county where the violation occurred, and the clerk shall assist the petitioner in preparing an affidavit in support of reporting the violation, or they will direct the petitioner to the office operated by the court that has been designated by the chief judge of that circuit as the central intake point for violations of injunction for protection, where the petitioner can receive assistance in preparing the affidavit to support that violation. The affidavit shall immediately be forwarded to the office of the state attorney in the circuit and the judge who is designated by the chief judge to receive these affidavits and review these violations of injunctions. The procedures relating to the reporting are governed under 784.0487 Florida statute. The respondent, upon service of the injunction, and now that typically happens if the respondent's there in court, they will get a copy before they leave. And the same with the victim, they will have that copy in their hand before they leave that courtroom. Upon service of the injunction, the respondent shall be deemed to have knowledge of and to be bound by all matters occurring at the hearing and on the face of this injunction. The temporary injunction, if any, entered in the case is extended until such time as service of the injunction is effected upon the respondent. So say a temporary injunction was put in place right after the initial review by the first judge when the petition was filed. Say the respondent is served and then chooses not to appear at the hearing. There is no gap in time between when the injunction is enforceable. As soon as they're served, it's in place throughout until the expiration of the final injunction. And then at the bottom, they have the date the judge signs. Copies are sent to the sheriff's office. So the sheriff's office in that county, they should be able to pull it up in their system. However, when you have to report a violation, you want to make it as easy as possible. You don't want any deterrent from them proceeding. So you want to make sure that you have the copy available for the law enforcement officer, any evidence, screenshots, text messages, photos to provide to law enforcement at the time that you're reporting the violation. And also there is how the petitioner or the attorney was served, how the respondent or their attorney was served. So if they're in court, it says by hand delivery in open court, but make sure that one of those boxes has been checked for each party. You also have the clerk who signs, and then on the final page, you have the acknowledgement. And so that's why you want to make sure that right after the hearing, they'll come to both the petitioner and the respondent with the original order, and both the petitioner and the respondent sign that order. So if the respondent's not present, it is left blank. So just some information, because stalking is really the focus of my practice. So I have a full-service victims' rights law firm, but I represent victims of stalking, cyberbullying, revenge porn, sexual violence. And so I do everything from the injunction to the criminal case, representing the victim throughout the criminal case, reporting the criminal case, or any related civil issues. And I focus mostly on the stalking cases. And so just some background information of why this is such a problem. 76% of female homicide victims and 85% of attempted female homicide victims have been stalked by their intimate partners in the year prior to that murder. 54% of female homicide victims and 46% of attempted female homicide victims reported that stalking to the police before they were killed by their stalkers. 59% of female victims and 30% of male victims are stalked by current or former intimate partners. 81% of stalking victims who were stalked by an intimate partner reported that they had also been physically assaulted by that partner. 3/4 of women who experience stalking-related behaviors experience other forms of victimization, sexual, physical, or both. And the reason why I think that stalking is such an important area of the law is I see it as an area where the law is being proactive. And yes, the victims are under a lot of stress at that moment, but what you see is if you can't put a stop to it, it will continue to escalate. Once the respondent doesn't get the response that they want from the victim, it gets more and more extreme. And you see a lot of times if the stalking cases aren't addressed right away, it does rise to the physical violence. Types of stalkers. There is not one specific profile or type of a stalker. It can be male or female. The relationship between the stalker and victim, they can be in a past intimate relationship, acquaintances, co-workers, or even complete strangers. Stalkers can be motivated by anger, revenge, jealousy, or an absolute fantasy or delusion. The generally accepted typology of stalkers, they're in a few basic categories, but the stalking behaviors that you look for, following, surveillance, they send gifts, letters. So even if they're sending handwritten letters or mailing letters saying, I love you, forgive me, I want you back, if it's unwanted contact, that can be sufficient for stalking. Vandalism, stealing items, threats, either explicit or implicit. And if it's an implicit threat, you want to make sure that you convey either in the narrative portion of the stalking petition, through testimony at the hearing, and also in a detailed written statement to law enforcement, why those implicit threats are so important to you. What does that mean? Identity theft. So if you're in a close relationship with someone, you've lived together for a while, they may know your passwords. Make sure you change every password. They may try to open up a credit card in your account. You may want to have the victim run their credit history to make sure that no accounts have been opened. The stalker may target third parties. So once the victim blocks them on social media, they may try to reach out to family members of the victim, friends of that victim, to try to see where the victim is, how they can get in contact with the victim. The physical or sexual assault, that could also be part of that stalking behavior. Workplace stalking. So they may show up at your workplace, or it may be someone from your workplace. Harassment through the legal system. And so that's where you see the filing of these false reports. You see these false allegations to DCF, things like that. The use of the children to harass or monitor. So say there is a child in common. Now, if that child has a cell phone, the respondent may have turned on the GPS locator. The respondent may have installed an app that can actually monitor that cell phone. They can turn on, I'm not going to get into detail about what can be done because you don't know who's actually watching this, but these are things to consider. If the respondent shows up, at the mall, at dinner, when, the petitioner is with that minor child, and these are things to consider, to go to law enforcement, to get additional information, to make sure that the victim is as safe as possible. The impact on the victims. So there's a lot of self-blame, guilt, shame, embarrassment, frustration, shock, confusion, fear, depression, emotional numbness, decreased ability to perform at work, school, daily tasks. You see a lot of times they exhibit the same symptoms as PTSD. They may have sleep disturbances, nightmares, sexual dysfunction. And so these are very important things to bring out throughout the testimony, and also at the end of the narrative portion of the petition. You have to show substantial emotional distress as one of your elements for a stalking petition, and that's where these elements come into play. And so if they are losing sleep, write that down. If they've had to change their phone, write that down. Have them testify to that. Change their phone number, take all of these steps to block the respondent. What has been done that has interrupted their daily activities that they didn't have to do before the stalking occurred? If they are crying, if they're upset, if, whatever that impact is, make sure it is conveyed to the court. Helpful evidence. So for a stalking case, you want to make sure that they keep a detailed log or a journal of all of the incidents that have occurred. You want to make sure they have screenshots, copies of the messages, or images that support their case. Report all incidents to the proper authorities, including parents, teachers, resource officers, police officers. You want to make sure that the victim is protected and that they are doing everything they can to stay safe. Request copies of all reports and written records relating to the incident. So if they've had to call the police in the past, go and request a copy of that police report. See what the officer did. Did the officer call the respondent? Was the respondent there? Talk to the officer. Say, what do you remember about the respondent? What was their demeanor? What did they say? What was your, how did it appear to you? Safety planning, and we talked a little bit about this at the beginning, but you want to make sure that the victim speaks with a police officer, victim advocate, or someone with victim services to make sure that they're taking all the necessary steps to make sure they are as safe as possible. You want to report the incidents to your local security guard, resource officer, police officer. Make sure that the local authorities are alert. Call to request local police have an extra patrol in your neighborhood. Provide a description of the respondent and of the vehicle. This is very important, especially when you're filing the petition. You don't know how the respondent is going to react, and so you want to make sure that local law enforcement or your local security guard for the victim is on notice, and they know to look out for this person. And also the day of the hearing, so right after the hearing, you want to make sure that they're on notice and maybe request an extra patrol. You want to have the victim safety plan before filing the injunction so they're as safe as possible. and have a safety plan for the day of the hearing. So make sure that they don't come to the hearing by themselves, because even if the respondent doesn't show up in court, they know where the victim is going to be on that day at that time. And so if they have to park in a parking garage, try to see if there's someone who can go with them. And also, after the hearing, most of the time I request law enforcement to escort the victim to their car, and that's something that they can arrange at the hearing. If you have any questions, you can reach me by email, smyron@cagnetmyronlaw. I have the information here. I hope that you all take a lot of pro bono cases, and I hope that this helps a lot of victims out there. Thank you.